You look like you look like some fog in your area, Bob.
Yeah, yeah, that's just, I probably have a dirty screen. I'm in in my little office in Raleigh, so uh, I don't. Hopefully, there's no fog in here other than in my brain. Well, let's do that. While we're waiting for John to get in, let's get started uh, on this. To our committee members here, and to Jennifer, my co-chair, uh, the um, uh, the committee needs to be deciding, what are we going to do our report on? What are we going to focus on? One of the things that I've been talking about, but we haven't had a discussion of, is this Article 6 provision in the Constitution dealing with Article 3 offices, which are all your Council of State offices. And Josh, you're too young to have been around when this case was litigated, I assume.
It's not. I read about it a lot when I was afraid you guys were going to use it with McCory.
Well, we've got the two instigators in part here. John Wallace, who is still trying to get in, and Mike Kroll. Um, for those of you who don't know, both of these gentlemen are extraordinarily experienced election law um, attorneys. Mike worked at the Institute of Government for a while, practiced law for a while, brought a lawsuit in the infamous case of Brannon versus Board of Elections back in 1992, trying to put me out of my judgeship. We have remained friends over the years, fortunately, since I won that election, despite the litigation. But
it turned out to help you.
Yeah, it probably did. Anyway, what we're here to talk about is this Article 6 issue. And Mike, you want to go ahead and give us the background on it, and we'll hopefully get John in.
Yes, and keep in mind, this took place almost 20 years ago, so I'm gonna have to just make up some parts of it.
Yeah.
It was the 2004 election for Superintendent of Public Instruction. June Atkinson was the Democratic candidate. Bill Fletcher, who was a Wake County School Board member, was the Republican candidate. It was a close election. I don't remember quite what the difference was. I do know that there were several issues with the election. There were, for some reason, and John Wallace may remember this, there were like 4,000 ballots that didn't get counted in Carteret County, or something happened. But the issue that Bill Fletcher raised, and there were actually 3 lawsuits. This was one of them. And I have to give credit to Bob Hunter for starting all this. Lawyers sit around and look at these provisions of the Constitution, and Bob Hunter thought, I don't know that it's okay under the North Carolina Constitution to have out of precinct provisional ballots. That is, people show up at the wrong precinct. Instead of being sent, you shouldn't be voting at the fire station, you should be over at the school. Instead, they're given a provisional ballot and it gets counted. And Bob read the Constitution to say that shouldn't be allowed and those ballots shouldn't be counted.
Yeah, Mike, let me chime in real quick. There was an article that Jennifer had sent around to me that Bob Joyce had written shortly after this. There was like an 8,500 vote difference out of 3.5 million, and there were maybe 11,000 provisional ballots floating around out there.
And we never knew for sure how many there were. There's one of these things, like you can get lawyers to look at the constitutional provision about free elections and try to make something out of it. This was Bob Hunter's idea of making something out of a constitutional provision people had ignored. Anyway, Fletcher followed the regular course for an election protest in North Carolina. He filed protest in all 100 counties, had hearing with the State Board of Elections. The State Board of Elections turned it down. That was appealed to Superior Court, and the Superior Court turned it down, and then it went straight to the state Supreme Court, of which Justice Edmonds was one of the members at the time, and I think he recused himself, if I remember correctly. I'm not sure why.
I'm guessing because he was a candidate.
Maybe you were on the ballot at the same time. I don't know, but at the Supreme Court, the clever John Wallace argued.
Who has now arrived.
John Wallace argued that the court didn't have any jurisdiction, that under Article 6, Section 5, it was solely within the jurisdiction of the legislature to decide the election for a council of state office. The Supreme Court did not agree, decided that the regular election contest process should proceed, and also decided that Fletcher was right about the out of precinct provisional ballots, and sent it back to the Board of Elections to decide the contest. This is sort of, if you look at Article 6, Section 5, what it says is that contested election for Article 3 shall be determined by joint ballot of both houses of the General Assembly in the manner prescribed by law. And our point was the legislature had prescribed a manner. It had done so by enacting the provisions on election contest, that those provisions have been used for contests for all offices, and that was simply the process to be followed. The General Assembly reacted, and keep in mind, this is a time when things were flip-flopped. At that time, the legislature was controlled by the Democrats. The General Assembly reacted to the Supreme Court's decision by changing the law, by setting out a new procedure for the legislature to determine council of state races and to take it away from the courts altogether. The legislature then enacted a procedure and held, held a hearings, I guess you call, or a trial that went on through the summer, and on strictly partisan lines, voted to seat June Atkinson, the Democrat, rather than Bill Fletcher, the Republican. I think we tried to get the court to look at it again, arguing that the new rules couldn't be applied retroactively, in fact, retroactively to the 2004 election. But I think at that time, the court didn't want to have anything else to do with it.
Let me interrupt just for a minute here, Mike.
Mhm.
And see, John, now that you're on here, and since this apparently was your brainchild, all blame goes to you now, John. You want to chime in on this story?
Before you do, John, I met a couple of people a couple of days ago, Martha and Richard Peck, who claimed to be good friends of yours.
And he related that to me, and I'm sorry you and I haven't crossed paths in too long, Michael. Good to see you. And I appreciate your recitation of that history. Some good bit of it I do remember, and some of the nuances I don't remember as well as you do. The one thing that one of the things that I do very distinctly remember is that the General Assembly leadership in both houses did a really good job, I think, in appointing members of the joint committee that heard and determined the matter for report to the full bodies, Senate and House. And it was an interesting process because it was in the nature of a litigation with discovery and then oral arguments, briefing, and so on to this joint committee. I remember in particular that the statutory scheme, or at least as I remember, the statutory scheme was designed to allow the General Assembly to make the committee to make a recommendation to the full General Assembly with respect to which candidate received the most votes. And I think that there was, as I recall it, there was a request for admission. I remember Bob Hunter acknowledging that June Atkinson had received the most votes, and that was, I think, determinative in the committee and important, of course, as it went to the joint session of House and Senate. The incident that arose in Carteret County is irrelevant really to the work of this panel, but it's mildly amusing. As I recall, the election equipment that they used counted up to 10,000, and after it got to 10,000, it started counting back down, so that it was impossible to, at first blush, to determine the outcome of the Carteret County election. That equipment was, of course, no longer used after that experience. So,
Yeah,
yes, Bob.
Yeah, let me and Jill, Josh, Bob, Rachel, chime in with questions here. So, two things. One, the status of this process today going into the 2024 general election. And then, I've got a couple of questions about, I won't say necessarily the constitutionality of what the General Assembly has done, but, could we see this play out in the 2024 election? And is it a good process? I mean, that's what our committee kind of wants to be able to respond to. Is this something that needs changing? But explain the status of things right now.
May I make an argument here?
You may, counsel.
I might disagree with John about the fairness of the proceeding in the legislature. Our perception was that it really didn't matter what was being presented, what was being argued. We were going to lose on a strictly party line vote, and that is what happened. And I will tell you also that I lost a certain amount of Democratic business for a while after that as a result. The statute is written, as I understand it, says that as soon as a candidate for a council of seat office files with the legislature an intent to contest it, then that takes away any jurisdiction of the State Board of Election or the courts. And that it is a final and unappealable decision. As I read the statute, what could happen is, let's say in the 2024 election, let's just say hypothetically, that Mark Robinson loses the race for governor by 4,000 votes. And there really isn't any, there really isn't any question about, I mean, he files protests, but they don't seem to have that much merit. He could then go to the legislature. They would take it away completely from the courts, from the State Board of Elections, from any determination of who got the most votes, and could vote strictly along partisan lines. And as it's written, there would be no appeal to the courts from that. That contrast, as I understand it, from the way Congress handles the challenges to congressional elections. I think the federal law, and others may know more about this, but I think the federal law is fairly clear that you go through the regular state election process and certification of results. And in fact, I don't think you can contest a congressional election in Congress until you have a state certification. And then the House or the Senate can decide on the qualification of its members. And I'll shut up after this, but if you've been around long enough, the lesson you learn about election law is that whenever one party enacts something that seems to favor it in a particular situation, it's going to come back to potentially bite them in a later election.
Yeah, and I would toss in, and I didn't realize this until Mike sent it to me yesterday. The General Assembly went ahead and put a provision in the statutes to deal with contested legislative seats in exactly the same way. Is that correct, Mike, John? So, I mean, essentially you could have the General Assembly deciding any and all contested Council of State and legislative seats. Would that be a fair assessment, John? Yeah.
Yes, and by and large, I would agree with Michael with respect to one aspect of this. Michael, I don't think you and I have discussed the 2004 general election and the post-election processes since then. But I would agree with you that the Board of Elections should have jurisdiction to do the fact-finding, relying, of course, on its county boards, and then determinations made based on the evidence received from those county boards, such that the body best able to gather the evidence can receive it and evaluate it. I think that's where that determination should lie. And Bob, I think your or somebody's memory of the congressional process is correct. I represented Charlie Rose when Robert Anderson challenged the 1994 congressional election, and we went through the process at the state board level, and then went to the Congress, and then it was a good long time in Congress before that matter was finally determined. And to Charlie Rose's detriment, the control of the House had changed in the 94 cycle, and there were a lot of people trying to get even with him at that time. So it was a painful it was a painful process in the Congress, but ultimately resolved in Charlie Rose's favor.
Yeah, let me start the questions if I could, because this one's really been nagging at me. You know, the Constitution says a contested election. Is there anything in the case law or in this process that determines when an election is contested? Because if you take it in its broadest sense, you know, every one of those elections is now contested because you've got candidates running against each other. On the more narrow, most narrow reading of what is a contested election, I would have said prior to Fletcher versus Atkinson that it means that you've run the legal process and they are simply unable to determine who to certify the election for. And, you know, which essentially at that point, the elections process and the courts say we can't tell who won. Then it would go to the General Assembly. But under this legislation, it would seem like the day after the election, if it's relatively close and you think you got some kind of legitimate argument, you file it, you go to the legislature as a contested case. Josh, you're shaking your head. Is that your understanding of it, or is
I think
that?
that's the legislature's understanding of it because it's a very quick trigger. So it's the same filing both for a legislative contested election and for a council of state. And it simply is just a filing. It doesn't even say who has standing to file it. So they've not even, you know, beyond the kind of case and controversy question, doesn't even say who would need to do it. So it literally is just once the paper's in the clerk's office, it's now contested and it triggers this proceeding and divests jurisdiction. I mean, that's the worst case scenario part of it, which is why I'm concerned that it will go well beyond the bases that have been used in prior protests and contested proceedings, and instead just be, if you have a deadlocked county board at canvas, if we get the 2-2 county board level, well, then it's results are indeterminate, kick it up, right?
But there's no process because of the judicial provision that says once the contest is filed with the General Assembly, the courts have no authority on any of the issues surrounding the validity of provisional votes or, you know, whatever the issue might be.
Yeah, they haven't built in an exhaustion requirement that you have to have previously brought your situation to some other body, it divests jurisdiction, and then under K provision, it's non-reviewable. So I've stuck those links in the in the chat thread for you there.
Yeah, not only is the court out of it in the decision making, but there's no review from what the General Assembly does, which maybe raises some legal questions. But Mike?
My reading of the statute is not only that when the notice is filed with the legislature, it not only ends any court involvement, it also ends the involvement of the State Board of Elections. Is that your view as well?
Unfortunately, yeah.
And
I
you
think
know, you can contrast the situations we're talking about with the way the 9th Congressional District was handled, which followed the traditional election contest process in North Carolina.
Right. And to Justice Orr's point, exactly right. We were working with the committees of jurisdiction in Congress, and the only time they were going to assume any jurisdiction was once we had certified. So there was an exhaustion thing because it's a membership-based power that they have to decide who gets to sit with them versus a adjudication of a contested proceeding.
Music. That's you, Edmonds. He's looking puzzled. All right. Well, let me ask our two experts, and Jill, you've done election work at the local level, and Josh, obviously you've been at the state board. Does this concern you? I mean, not just from a sort of partisan perspective, but from a good government process perspective, should we be concerned about this? And, what sort of changes should we at least put out there as for the public to consider? Because I don't think anybody knows about this in the greater scheme of things. And, my God, if the elections are as close as everybody thinks they potentially could be, you could have multiple races, jump into the General Assembly. So, any concerns, John, Mike, Josh?
I've expressed mine, and I'm an interloper here. I'm not a member of your committee, so.
Well, you're one of our experts. John, you had wanted to say something, John.
Yeah, I'm greatly concerned about it. Let me just let me go back and just address the 2004 situation. Along the way, I became aware of the constitutional provision, but I did not want it to go to the General Assembly. I thought the State Board of Elections should have that ultimate decision-making power, but the Constitution said what it said, and as I recall, the Honorable Mark Martin put some challenging questions to me in the course of that argument, but it wasn't until after the Supreme Court had heard argument that I think a lot of things sort of ran through the General Assembly very quickly. And I'm a little fuzzy on the exact sequence of events, but I think, Michael, tell me, the State Board had already finished all its work, had it not?
The State Board had rejected the original challenge. It had been to Superior Court. The Superior Court had upheld the State Board, and that was appealed to the Supreme Court. The Supreme Court sent it back, having decided that the provisional ballots should not count, sent it back to the State Board, and that was going to be as I said, we never found out exactly how many provisional ballots were affected. We never got to that point, but the Supreme Court sent back basically to the State Board. That's when the legislature enacted the new provisions and cut off any involvement of the board or the courts.
As I recall, the Supreme Court expressed regret that the Board of Elections had expressly allowed out-of-precinct provisional ballots to be counted, and then sent it back with that direction. But it was not our goal at that time to get it into the General Assembly. We were just confronted with the statutory, the constitutional language and the Supreme Court decision. I would not want the General Assembly to have that immediate right to take over a contested election based on the mere filing of a notice, while the State Board of Elections still has a process to complete. And so if there was one thing to urge upon the General Assembly now, it would be that statutory scheme be amended to allow the State Board to complete its work.
And would you also say, and to run through, so if, as I recall, and I may be wrong on this, but that nobody ever made a formal decision on the constitutionality of the provisional ballots and whether they would count.
That's correct. The Supreme Court said we don't have to decide the constitutional issue. We can decide on a statutory basis. And so they did not reach the constitutional issue.
So would the other reform measure being that there should be some sort of judicial review? Doesn't the candidate have, some right to?
To your point, Justice Orr, I think you almost could, there are a couple areas where we could mess with this in a way that would be productive. Probably first to clarify standing, because we're all talking about it like it's a candidate initiating these things, and it's not at all clear from the enabling statute that it's limited to a candidate who can kick this thing off. So it'd be good to limit that, because I think the legislature might get on board with it. The second part is what you're pointing out, the need for fact finding. So they're not just voting based on partisan vibes, right? Somebody needs to decide facts. And if it's not the state board, and if that's not within their Overton window of things that they're willing to do, it could be, a specially comprised, expedited proceeding, Wake Superior Court, something that just produces the facts. And then to John's point, narrowing the scope of inquiry into who got the most votes. Because right now there's no limiting principle on which they're supposed to base their decision. And it sounds like back when your proceeding was going on, that was material that you got the legislature on board with, saying at least that they were just trying to determine who won, which is different than just who should be seated. Because right now they could just kind of say this is the right outcome as opposed to here's why, right?
We, of course, disagreed as to the number of votes because we never found out how many of out of precinct provisional ballots had counted.
Well, let me.
Sorry,
I'll
shut up.
Sorry, Mike. This is Bob. We're talking, of course, about North Carolina here, but there was an op-ed in the Greensboro paper yesterday. I sent a copy to Bobby and to Jennifer about how the Trump team is nationally putting lawyers in the field to be ready in case he does not, there's a contested presidential election. So to me, that raises the likelihood that this is not going to continue to be overlooked. And Bob's question about, are we going to see litigation along these lines? Are people trying to take advantage of this provision? The answer is probably yes.
Josh, you seem to know the answer to this, and John, you as well. As I understand the congressional process, it's that the state election officials have to go through the certification and issue a certification before Congress will touch it. So is that what you want to have happen here, that allow the State Board of Election to complete the certification before the legislature gets involved?
I mean, they're different enabling authorizing powers, right? Because Congress flows from their membership authority and self-rule of their own body. And then this flows from a totally separate constitutional provision. I think there is a world where you could overly constrain that constitutional authority that's held by the legislature. I mean, in principle, I'm all for it being just going through the normal process and only taking these extraordinary measures once the normal process has failed. And so you have some kind of exhaustion requirement before any proceeding. But I think, under the current construction, I think the legislature has to have some power, and I'd rather there be a statute that's there instead of just this vague constitutional provision. But it's currently not a great statute.
And you have the problem lurking in the background that if somehow we end up with an even number of state board members and a state board that was split 4-4 or whatever it is. Bringing
Sorry.
the issue that I know you're really interested in, which is, I'm sure your commission is in the forefront of wanting to do something about getting unaffiliated voters on boards of election.
Yeah. Philosophically, we are.
To Justice Edmonds' point, though, I think that's absolutely right. That the likelihood of some type of parallel avenue if it's close at all, which, current polling trumps up by 6 in the state, right? But if it gets close, then the likelihood that everybody, the Council of State folks and the Trump campaign, will kick off all of these kind of extraordinary measures. Because if you do have that 2-2 county board level, all you need is Mecklenburg, probably just Mecklenburg, to not sub-certify the Canvas results. And then results are therefore unknown. On the presidential side, that means that the legislature is under this time clock under the federal statutes to certify who their electors are to Congress. You could get around most of what the Supreme Court decided about the legislative powers, in that recent case, by just saying, hey, look, we don't have results. And so we're going to kick in our normal constitutional authority to decide our electors. And so you could have the legislature feel like it has power there and then know that it has power on the Council of State level. And so I could see it getting really wild. So you're absolutely right, Justice Edmonds. This is unlikely to stay a secret long.
Let me just interject that one of my observations over the last several years is that we've had some, what I consider to be specious protests. They were really challenges, and Josh, I'm sure you will remember the 2016 protests filed challenging these purported double voters based on protest forms prepared based on flawed data. If you had a situation like that sort of lurking, the state board might decide it all denying those protests, but that just hanging out there creates a problem upon which to claim the election was contested. During the course of the 2020 cycle, we had another round of what were essentially challenges to dead voters, allegedly dead voters, in these blanket protests filed in, 10, 12, 15 counties. And they were just names from newspapers of persons who died, and the product of an effort to match up names with persons who cast early votes or absentee ballots and then died before Election Day. But again, it was sort of a broadside attack on the votes of individual voters, but it swept along the lawfully cast votes of any number of other voters, and it again cast a shadow over the count in each of several counties, and that could also provide a platform upon which to claim that the election was a contested election. And I think there needs to be some constraint on these broadside protests that are really challenges brought in gross rather than individual challenges which could have been brought to the votes of individual voters. But it casts a doubt on the vote count in each of the counties in which those protests were raised. I would like to see some constraint on that.
Let me go back, and this sort of fits in, I think, to what you were talking about, John. How would you define contested? I mean, right now, if contest, like I said, you've got the full range of the process. How should contested election be defined for purposes of this constitutional provision?
Bob, I don't know how you would define it other than an election which is subject to an election protest. Josh, do you have any better definition than that?
I mean, if we were doing a new statute, then I think that's where you would get in kind of this, you define it procedurally. So it's only contested for legislative purposes once it's already hit step A, B, and C, either in the courts or the state board or both.
But would you still consider, if you've run the process and the state board says, we think we're going to certify June Atkinson because after this ruling by the Supreme Court. Could the candidate still say, well, I think that's wrong. I'm going to go into the General Assembly and see if I can get a different result, which, you know, I mean, it's pretty tempting, you know, at least in a partisan context, to say, okay, well, the Board of Elections and the courts have ruled against me, but I'm still only down 1,000 votes out of 6 million, and so therefore I'm going to the legislature. And so because I would like to say I would take the most conservative, small c conservative view, and that is a contested election is one that after you've run the process, you can't be sure who's the certified winner. And then the legislature would be able to do it. Now, but there's nothing like that now, though.
That's more akin to the federal standard, I think.
Right.
Before others respond more, I'm going to excuse myself. I'm a guest at this, and I've already said more than I should, and you'll be better off without me here. So it's good to see all of you, all except Jill, and know pretty well. Good to see you. And, thanks for including me for a little while, and good luck to what you're doing.
If you go to the beach to Wrightsville or Wilmington and you want to talk election law, call Jill. She's ready to go.
So long.
Mike, thank you.
Good to see you, Michael.
I appreciate it, buddy.
Thanks, Mike.
Well, for the committee members here, I've got a young law student who's doing the 4-year plan with the School of Government, who is going to help do the report we're supposed to be doing for it. But I just want to make sure that the committee considers this one of the 2 or 3 things we ought to be reporting on. And Josh, I may have the young man's name is Patrick Brady. You may know Patrick, but he was a Moorhead at Carolina, and he's worked in politics. And anyway, he's a smart young man. He had some free time. Asked me if there was something that he could do, so I thought this would interest him.
Great.
But Josh, I think we need to be able to report, here's the state of things, here's how we got here, and here's what's going to happen or procedurally. But here are the questions that we have about whether this is the best practices going forward. I don't think we can't impact the 24 circumstances, but I do think, or John, you're our guru. Would you prefer that the public doesn't know about this, or
Bob, I think the secret's out.
Yeah.
And I'm not sure that I have a lot of confidence in the General Assembly fixing the statutory scheme in the way that I would suggest, or that this body would suggest as the best path forward.
Well, the public and the press, though, I mean, hopefully, and that's sort of the benefit I'm looking. We're supposed to do an interim report midsummer. It's not a final report, but I think this one particular issue, above any of the others I've seen, might generate some press and public attention on it.
Bob, let me ask you a question, though. To deal with this, do we need to do it at the constitutional level or at the statutory level?
Well, if you're going to change the constitutional provision. Obviously, you got to, do a constitutional amendment. But I mean, to me, if there was some interpretation of contested that puts substantial limits on when somebody, whether it's a random person or a candidate, if you could put some limitations on when it comes and how it gets there, that would be a plus. And I don't know, John, do you think anybody would challenge the lack of judicial review as separation of powers issue? I mean, granted, we don't have the most sympathetic court sitting there to hear it, but I mean, I find that problematic that we can decide the election and you have no recourse.
As I recall, and Mark Martin may have been Chief Justice at the time. He was surprised about the lack of court jurisdiction, or concerned about the lack of court jurisdiction at that point. I don't think that I remember with precision, but this constitutional provisions have survived I think it was the 1971 rewrite of our Constitution, which is just kind of astounding to me. But it's been embedded in our Constitution for a long time.
Yeah, I think Atkinson's probably your brief. Mike sent a copy of one of the briefs to me, and in talking about the history, it went back to 1835 when the governor was first publicly elected, as opposed to the legislature doing it. So, I mean, there's a lot of history, but a very different election structure now than when it first went into place.
Yeah, we did not have, and I will say this in praise of our statutory scheme. We've had a system in North Carolina that has been both successful and is highly regarded beyond the borders of the state of North Carolina. I mean, we have had a very successful experience with a board of elections, and that constitutional provision was first inserted into the Constitution and should have been considered when the 71 Constitution was adopted.
Yeah, I'll have to go back and look at those notes from the Constitutional Convention, or not convention, but commission.
When I argued this thing to the Joint Legislative Committee, Senator Clodfelter didn't seem as interested in the number of votes as he did in the history of this constitutional provision. It's always challenging to argue with Senator Clodfelter about this.
Well, June made a good superintendent of public instruction, so we can take that.
And Bill Fletcher would have been a fine superintendent.
Yeah, Bill would have done a good job too. So, as opposed to the race this year, the current race this year, which is a little more problematic. Actually, I mean, that could be the race. I mean, you could have, the superintendent race come down to going to the legislature. The attorney general. I mean, that's sort of the frightening aspect of it, is you take all of the really critical council of state races, throw in a few legislative races that maybe determine a supermajority, and it could be.
I think John makes a good point. The General Assembly is not in the general business of denying itself power. It's going to be a sort of self-denying act to get them to to go so far as to put just a definition of contested in.
Well,
I think Josh is
right. It's just going to be a tough road.
I think Josh's suggestion is a good one. I just don't know that I think it would get through, but I would certainly urge that it manage to make its way through this General Assembly.
And I think that is the point of this commission, is to give some bipartisan weight, whether it goes absolutely nowhere, but to give some bipartisan weight to these are the best practices. I also want to apologize to all of you because if I seem off today, John, after we got off the phone yesterday, I was sitting at a picnic table with my leg under me and I did not realize that it fell asleep. And I stepped into gravel and my body crumpled and I have broken my ankle.
Oh,
So
no.
I am in like seeing stars pain. So if I seem off or not as participatory, that is why. And I apologize to all of you and thank you all for being here.
Well, I am so sorry, Jill. I thought maybe you were just reading your cell phone. I was
No,
as opposed to agonizing there.
I'm sorry, Jill.
no,
Yeah.
it is okay. I'm
Yeah.
getting old, clearly.
All right. Well, I hope you got a good doctor. If you don't got a good orthopedist in Raleigh that's been treating me. So.
I do.
Even if you can't kick rear ends, you can still take names. So,
Yeah.
Oh, feel
Well,
better.
I do think getting this out there for the broader public and the media and even the business community, there needs to be a broader understanding on it and making some simple proposals like running through the certification process like Congress. I think that would be a plus. You know, the biggest problem, John, is that the Republicans have the benefit of saying, well, we didn't do this. That was John Wallace and the Democrats that put these rules and all of this in place, and
I would remember it a little differently from Michael, but I did think the General Assembly put together a very, very fine panel to hear and determine this matter, and I don't remember one way or the other whether it was a strictly partisan vote in the full body. I remember it somewhat differently, but I'll go back and take a look at that.
yeah,
And I sincerely don't remember talking with Michael about the substance of all of this in those almost now 20 years.
Yeah. Well, I would say from what I read, Deborah Ross and Dan Blue were the co-chairs, which, would give me great confidence in the quality of the committee making the decision. And there were maybe 24 abstentions. They said they gave them three choices. Atkinson's got the most votes. Fletcher's got the most votes. We don't know who got the most votes. And then there were some that just didn't vote. And then were maybe 20 or so that said, we can't tell who's got the most votes. But, I just think putting some scrutiny on this. And Josh, if I could ask you to kind of be our lead with Patrick, and I will give him your contact information, because we're supposed to have at least some kind of rough draft mid-June here. But and John, this is beyond the scope of why you were asked to come today. But the second issue was the one that Michael McKnight talked about. And John, I'd be curious your take on it. Michael was talking about how it was becoming more difficult to get lawyers to do election law work, either partisan or, on a more neutral basis. Are you finding that, Jill? Are y'all finding that on the Democrat side, or are lawyers coming out of the woodwork?
It's never been easy. I mean, quite frankly, it's never been easy. We were very fortunate in 2020 to get Melanie Dubas and Bruce Thompson to pitch in support of Sherry Beasley. It was a very substantial task to contest the many protests that were filed And the same was true in 16, contesting the many protests that were filed just after the election. And we had to go beyond our firm, and there are not many firms beyond our firm that do substantially election law work.
I mean, we're making a concerted effort at the state level due to our amazing new voter protection director of getting attorneys in every county. Do I think, like, did I tell them the other day that I think that you have to start from the assumption, like, we are a very well-organized county. We don't have a county attorney. It's essentially me and some others that act as a committee. But I did tell them that they have to start from the place of like, you probably don't have one, or you're overestimating how developed this program is. But I know that they're actively working on it, and I could not support it more.
Bob,
Well,
starting in 1984, we put together a network of lawyers by county. Some lawyers from the less populous counties covered multiple counties, but we've had a county lawyer network since 84. It was at its peak during the 2008 cycle. The Obama campaign drew lots of excellent lawyers into the campaign. But then in the years since, it's been harder. I think we will do very well this year. I'm confident we will have a very good network of lawyers this year. Now, our lawyers historically have had a different approach than, Laura Trump suggested that Republican lawyers are going to be handling ballots in precinct polling places. Josh, in my experience, that's not been our role. We don't aspire to that.
Nor should you.
Yeah,
I agree.
and that they were going to be filing preemptive suits as opposed to waiting. Well, I do think our second issue would be, how do we strengthen a stronger and I would say bipartisan cadre of lawyers who understand not only election law but sort of the underpinnings of what lawyers are supposed to be doing. Not, you don't necessarily have to be a D or an R, to be helpful in this. So that was the second.
Bob, to that point, I don't know why this has happened, but the General Assembly proposed that the State Bar put together a committee, and the Bar has put together a committee that's put out at least an interim report, which the thrust of which, the underlying thrust of which was that bar discipline was being utilized to stifle political speech.
Right. Yeah.
That's a committee chaired by Woody White, as I recall, and that report came out in the last month or so. Is that right, Jill?
Yes, and Woody White is like the Roger Stone of New Hanover County, respectfully to my Republican friends.
So that's happened, and then I'm dismayed by our Supreme Court's consideration of the defamation case, the absolute privilege issue that was considered an argument a week or two ago, maybe a month or so ago, all of which arose from the 2016 allegations made against voters in North Carolina, the suggestion being that those voters had double voted. But we're not on just one front. We're dealing with the Supreme Court and the state bar and the General Assembly. So there are several fronts in which we sort of need to bring things back to the middle.
Yep. Well, on a closing note here, because we try to keep these to an hour, and if Jill's sitting there in agony, I don't want to keep her. I want her to get her foot up and see a doctor. I will note that my fair elections lawsuit, the briefs are due today. We'll get them on our website here sometime in the next couple of days. The hearing is June 13th in front of the motion to dismiss filed by the legislative leaders. And the panel is Judge Foster, Judge Gore from down in Columbus, and then judge from Surrey County, whose name, woman judge from Surrey County, who's that's our panel. But you will appreciate this. I I use several quotes from the plaintiff's brief in Stevenson in our brief. So my friend Mr. Strack will have an opportunity to see some of his good government allegations brought back to him in the context of this argument. So anyway, I hope y'all will, another long shot suit, but one that if we've got a right to fair elections, maybe it helps us a little more in the context of what we've been talking about.
We applaud you, Bob. Thank you.
Well,
Great.
yeah, I may need prayers more than applause, but all right, Bob, Mr. Chairman Edmonds, anything else we need to kick around here?
I don't think so, John. Thank you very much. It's good to have your and Mike's input. And Jill, I see why your last name is Hoffman. No, seriously, I hope it's, you're up and running again soon.
Thank
Thanks
you.
for attending under these circumstances.
Yeah. Well, yeah, thanks for hanging in there. And Josh, thanks for your involvement. Be on the lookout for Patrick Brady. Okay.
Oh, well, grateful.
All right, guys.
You all.
Thanks.
Thank
Thank you all.